Quick shout out to Chad, who took the time to leave us a 5-star Google review over at Google My Business. Chad said, I've just started the podcast, but I'm stoked to finally have some resources from real people that have been tried and tested so I can eventually implement them for myself. Especially with the background of plumbing, it's relatable to me and makes learning easy as if I'm just having a conversation on site. 100% takes the confusion out of what has been a daunting task, not knowing where to start. I've already recommended it to other friends. Chad, thank you so much. Much appreciate you taking the time to do that. Folks, if you would like to leave a review, as you've just heard, I will read it out. And it does help us with our rankings, and we do appreciate it. So please, if you've got 5 seconds to leave a review, we'd very much appreciate it. Okay, thank you. Patents, trademarks, copywriting are all things that we need to consider as business owners. However, where do we start? In today's podcast, you are going to be learning about intellectual property law, which all of those other things fall underneath that banner. Quite an interesting topic of conversation, one that, to be honest, I really didn't know a lot about, and I'm glad I had it because after learning what I've learned through speaking with Anthony in this podcast, it has made me put a few things into perspective. I'm sure you will learn from this. It is very relevant to you as a tradesperson across the board, as a business owner, and I'm sure you'll get a lot out of it. Anyway, enjoy the podcast. If you have any comments, you know where to get us, and I look forward to hearing your feedback. Today's podcast has been proudly brought to you by Tradie Web Guys. Tradie Web Guys work with tradespeople only on their websites and marketing solutions to help them stand out from their competition. Everything from web design through to SEO, search engine marketing, content creation, you name it, guys. It is a customized solution for trade-based organizations, and it's fantastic. Head across to tradiewebguys.com.au/apply, fill in the form, and let's have a conversation. It'll be the best thing you could possibly do to kickstart 2019 the right way.
Giving tradies and contractors around the globe the tools to run a modern business. You're listening to Toolbox Talks from the Site Shed. Now here's your host, Matt Jones.
Anthony Verna, welcome to the Site Shed podcast.
Matt, thanks for having me. It's a pleasure to be here.
All the way from New York.
Halfway around the world, or all the way around the world, I guess.
Yeah, well, certainly a different season.
Yes, it was funny. The only time I visited Australia was in October, so I left the fall, and I arrived in, of course, the rising temperatures of the spring, and I certainly was not really prepared for that, and also, you know, Australian spring is not exactly cool and refreshing.
Well, it is for us. We're getting a bit of autumn weather at the moment, which is a nice change from the 35 degrees Celsius days that we normally get through our summer. So, yeah, it's good. But anyway, weather aside, we're here to talk patent, trademark, copyright law today. That's kind of your thing, right?
It is absolutely my thing.
I've never covered this on the podcast, and it's something I've been wanting to do for quite a long time. Respectful of the fact to all the listeners out there, we should probably disclose that you are in the United States, and anything you guys hear in this podcast take as general information. How is that for a legal disclaimer, Anthony? Pretty good?
I think that's a very good disclaimer.
Did I just protect my butt there, or what?
I think you did, Matt. I think you did.
We'll see, won't we? So, it's something that I've really been wanting to cover. We've spoken with, we've got quite a large community around the world, 4,500 tradespeople in a big online group, and a lot of the conversations, some conversations I come up occasionally in regards to trademark and things like that. But I've never really dived into it very much on the podcast, just because I didn't really have the right man. So you just fell into my arms.
That is exactly what my wife said.
Classic. So anyway, thank you for your time today. I know you're a busy man. I also know it's 9:30 at night, so we'll try and get through this as I won't say as quickly, but as efficiently as we can. We're going to cover off on a few things. We're going to be covering off on patents. We're going to be covering off on trademark, copyright, as in not in copywriting for a website, but actual registering copyright. And then we might talk about a few other things along the way, domain names, business names, blah, blah, blah. And this is kind of your thing, right? Like would you call yourself a patent lawyer? Is that your jam?
I would not call myself a patent lawyer because I am not admitted to actually file the patents myself. I do have a patent agent, and Will is a really smart man, and he really can get to the bottom of an invention and describe it well in a patent and get all of those claims written properly. I do have 15 years experience practicing law. I do have patent litigation experience from other firms that I've worked for, National IP Rights Center, Paul Hastings LLP, and of course now on my own as well. So while I am not a patent attorney, basically on the patent filing work that's done by Will, and of course when we're litigating, I'm the lawyer, and I'm the one who litigates.
So I imagine, and please, if I am completely ignorant when it comes to any of this stuff. As I was saying to you offline, my experience with lawyers and the legal side of things pretty much doesn't go much past suits. However, is a lot of the stuff when we're talking about patents, trademarks, copyrights, does it cross boundaries, geographically? I mean, there must be a damn lot of similarities there, especially when it comes to domain names and things like that.
Well, I would say that what crosses the most borders is the domain names.
Right.
For everything else, the answer is it's jurisdictional in nature. So if somebody comes to me with an invention and we do file an application here in the United States, it has absolutely zero bearing in Australia, has zero bearing in European countries. It has zero bearing in Japan or China. So you do need to be mindful of that. There is no such thing as a world patent.
Really?
And, yes. And it's funny that you ask starting there, because I just was asked this question last week because somebody did say that they had filed a world patent. And of course, there's no such thing. So that was, and I actually have an upcoming episode of my podcast, speaking with a colleague in Taipei about the fact that there is no world patent. And there have been a couple scammers here in the U.S., but I'm sure there are scammers everywhere that have made
we don't have any in Australia.
No. Everybody is forthright and honest.
Exactly.
There have been some scammers that have tried to advertise, filing a world patent and have made money that way. So
what does that actually mean then? If you do, respectful of the fact that probably most of the audience that are listening to this being, contractors and tradies.
Well, I have clients that are construction companies and contractors. So intellectual property does reach into these industries. Patents protect a new invention, and so let's make sure we get this terminology correct.
Okay.
Patents protect a new invention. In the United States, we want that invention to be new and novel. And if it is not a particular thing, so if we're talking about algorithms or business methods, we also require what's called an inventive step. And don't ask me what an inventive step is, because that is something the Supreme Court just kind of snuck in and added in there, causing the Patent and Trademark Office itself to kind of figure it out for about a year. Seriously, we were not. Our Patent and Trademark Office was taking all of these business method and algorithm patents and putting them to the side for like 6 months to a year, trying to figure out what that meant. Trademarks are any kind of brand, so it's a relationship between the company and the consumer. And the consumer can just be a person, or the consumer can be other businesses. So it doesn't matter whether your business is B2B or B2C. There is a consumer there, and that brand has a relationship between the business and the consumer. And trademark law is about protecting that brand as an asset. And also it's about making sure that consumers themselves are not confused.
So would that be things like names, logos, blah, blah, blah?
Absolutely. Names, logos, slogans. Sometimes it can even be colors, of course, depending upon your jurisdiction. And sometimes it's even shapes. For example, Toblerone.
Oh, yeah.
Well, actually, more like Toblerone. I'm sure Toblerone is sold in Australia.
Absolutely.
Yes, and when you buy it, what's the shape of the chocolate?
Yeah, it's triangular, isn't it?
Exactly. So that's a trademark of yes, exactly. Not just the brand, but in that particular case, the shape of the product. Copyright law protects what would traditionally be seen as artwork. And obviously, paintings, books, music. These days, we throw computer programs in there. And effectively, a copyright prevents anybody else from copying. Now, as to the degree of copying, it depends upon the type of art, frankly. It depends upon the work, and it depends upon what is being protected. There are some items in which what is protected is just these specific words. And sometimes in copyright law, what can be protected might not necessarily be an idea, but if there are not other ways of expressing that idea, then sometimes that idea is enveloped in the expression. But copyright law is about the expression of an idea. And that might not come into play for this particular audience, but that's the difference between a patent, a trademark, and a copyright.
So I'm a bit confused now, because if we're talking about trademarks, you can trademark things like logos, but in copyright, that's anything artwork. So is there a bit of a crossover there?
There absolutely can be a bit of a crossover. My general example in something like this could be any logo. So whether that logo is Mickey Mouse, Batman, or the conical drill in your local construction company. On one hand, there's trademark use of it because it's there as a brand representing the company. But there is a copyright aspect to it because, yes, it's a drawing that's made by a person. So it is a two-dimensional visual work.
Right.
So something can have aspects of trademark and copyright in it. So yes, your instinct is completely correct.
So in a scenario where, let's say, we have a builder who has designed a brand new spirit level, that would be a patent. So he would have to register a patent for that. Then he would have to go and register a trademark for the business name, the slogans and anything that's associated from a brand perspective. And then he would have to go and register copyright for anything to do with the design of it, or what would?
Well, yes. So you are hitting the nail on the head. Not to give you too many dad jokes here.
Excellent pun.
But but I had to look up spirit level because I never heard that.
Okay.
I call it a bubble level.
A bubble level. Okay.
Right. We're separated by a common language, of course.
Right.
But yes, if somebody were to create a new type of tool or a new way of using that particular tool, that would fall under patent law because it's a new product, it's a new invention, it solves a problem. There is something new and novel about it, and that falls under patent law. Once the patent is issued, although sometimes with a lot of my clients, we're doing it before the patent is issued because it takes a little too long to get it in today's world, at least in the United States. You want to start taking the product and you want to name it, and you need to give it a name, and that particular product's name will become a trademark. So from that particular standpoint, you've got the actual utility of the product being protected, and then you actually have the branding of the product also being protected. So there's patent law and trademark law working together to protect one particular product for a company.
So you said before there's no such thing as a global patent.
Correct.
So if I had a product that, say, my spirit level was, there's a potential market for it in the United States, would I effectively have to lodge for two separate patents in two separate countries in different jurisdictions? Okay.
Yes, you would. And I know that sounds frustrating, and certainly for a lot of my practice, for a lot of my clients that is frustrating, and I do understand why, and I do emphasize why. But frankly, it's a different country, different jurisdiction, different rules, and different cultures as well. So there might be, for all we know, there might be a similar product in one country, but not in another. So therefore, maybe a patent was filed in one country that protects a particular device, but was never filed in another. Right. In today's world, that's quite possible. So you don't want to rule that out. Therefore, yes, you do need to kind of go country by country. Europe's a little weird. There are European patents. It's not necessarily the same as having a patent in each country, but it is recognized. And, I leave that particular level of frustration to my friends and colleagues who actually practice in Europe. Right. So this way, they can just tell me what to do. But that can be a little frustrating as well. Like if you only have a European patent and maybe also to save some money, you only filed in the UK, France, and Spain, and there's infringement in Italy. It's a European patent, but it's not the same as actually having that particular patent filed in Italy as well. So what I would just say there is if you're looking at Europe, make sure you have highly skilled European counsel, because that can get a little tricky.
So with that in mind, is it a federal? Is it? It's not like state to state driven. Like you can have a patent in. Right. Okay.
Correct. So the great news in the United States is that yes, for the most part, intellectual property is on the federal level. Patents are on the federal level. Registered trademarks are on the federal level. If it's not registered, it does go state by state. And copyrights are also on the federal level, and a copyright must be registered. Else there is no right to walk into court if there's infringement.
And so is it the actual government that's issuing the patents?
Yes, absolutely. Those are in the United States, they're granted by the federal government.
Okay. That's interesting, isn't it?
Well, absolutely. I mean, I've had I've received some criticism in some political circles for being an intellectual property attorney, because of course it's the use of the federal government in order to enforce your own product. And some of my small government friends are really small government friends, so I don't particularly like that. But yeah, no, everything comes right out of the federal government in the United States.
We interrupt this podcast today to talk to you very quickly about Tradie Web Guy's content creation program. That program has been designed specifically for trade-based organizations as a way that you guys, as trade business owners, can start creating content that enables you to engage better with your customers and your potential customers. It will enable you to build trust and build rapport, because what you're doing is you're investing in educating them. The biggest problem that we see with our customers today is that they're not regularly updating their websites. And that's a problem because, first of all, the search engines are looking for that. And second of all, potential customers are also looking for it. Tradie Web Guy's content creation program has been specifically designed to help you get regular, relevant content on your website consistently every month. We know that it's hard when you're out there on the tools, and we know that sometimes you don't always have the time to be able to do these things yourself. So we're taking it off your hands for you. It's a service that we're offering for you guys. We want to make sure that you're getting this done because we know how important it is. Anyway, head across to tradiewebguys.com.au/content, fill in the form, and one of our representatives will come back to you. So one of the questions that I want to ask you is something that I've been wondering about, and this actually happened with a client of mine down in Victoria, and he was He was bringing a product in for distribution, and he had a letter from another competitor here saying they had a patent for it. And when his lawyers went digging around and they couldn't find it. And anyway, it turns out it was all a bit of a hoax. But if somebody's got a patent, what's the process? I mean, I'm guessing it's like going down a rabbit warren when you're trying to find a product, especially like how do you find the things? Like how do you?
So doing a patent search, and that's always our first step, because you want to do your best, and there's no guarantee, but you want to do your best to make sure that there isn't already some kind of disclosure, whether that disclosure is a patent filing or that disclosure is a product that's already being sold, so therefore it may be advertisements or something similar that already discusses the proposed invention of the client. Now, the problem with doing a patent search is exactly what you said. It's like going down a rabbit hole. You know, you could spend $1,000, $2,000, $10,000 in doing a patent search, and there is zero guarantee whatsoever. So what we try to do is we try to set a budget with our clients, and we try to search the relevant databases. So it's patent databases. Obviously, we need to do a Google search. We have a couple of other subscriptions to kind of match keywords and different types of algorithms. And we see what comes up there. It's more of an art than a science, to be honest with you. So, we just try to get as many sources as possible. Mm-hmm. And we try to make sure that we're covered, and we try to make sure that when we give our clients the result of a patent search, that we say, here are 10 or 15 that are relevant. And here's why we think yours is still different than each one of these.
Right.
It really is difficult to describe what the process is, because you're looking up keywords in order to really define, because what's a patent? It's an abstraction of an actual thing, and so we're looking at one abstraction, and meanwhile trying to relate to that to our client's actual product.
So as I was saying to you offline, my wife's Canadian, and her cousin is heavily involved in the canola industry in Canada. They grow a lot of canola, and they've actually got a patent.
Corn, sure.
They've got a patent on the molecular construction of the canola blah blah blah. Have you ever heard of that?
Yes.
Wow.
Absolutely. I don't know if in the US, there's a product called Smart Balance. And I don't know if it's sold as anything else in other, around the world. So I don't know if in Australia that has a different brand name. But basically, Smart Balance is a margarine, for lack of a better word.
Right.
But it has a very specific ratio of fats in it in order to supposedly help cholesterol levels. And if you go to their website, it says it supports healthy cholesterol levels. But the patent for the actual formula is a 1-to-1-to-1 ratio of certain fats,
right,
which for whatever reason had never been done before in all of human history. And so, yes, absolutely, there are patents on food for the molecular creation of plants. There are patents sometimes for recipes like this, if it really truly is something new, mainly because there'll be like a process as well that goes along with the utility of the product. And of course, if it's solving a problem and the creation solves an actual problem, like in this particular instance, the example I'm giving with the cholesterol problem, that would fall under patent law. So yeah, absolutely. And I know that sounds a little far reaching, but yeah, you can certainly do it on the right on the right level, depending on what the invention is. I mean, most drug patents exactly are that, on the molecular level.
Wow. And so This is it a database? Like when you go looking for these things, does all this information have to be registered somewhere centrally?
So yes, they're all registered at the Patent and Trademark Office.
Okay.
And
which is federal.
Federally, yes, here in the United States. And so when we go looking, it's in that particular database. We have a few different services because one database is never really enough because the search, really it's the searching algorithms from company to company that come up with different results. Right. So in order for our results to be seen in the best manner for us, for our evaluation and for our clients' information, we do try to use different resources, which is really still searching the same exact databases, just right. using different algorithms to come up with different searches so that we have different results.
Wow. Okay. And that whole database is effectively maintained by the government.
Oh, absolutely.
Okay.
Yes. I mean, you yourself, as a layperson, can go to the Patent and Trademark Office website here in the U.S. and go searching if you'd like. I will tell you that it's not going to be very good because it's just not going to be a very. You'll find all of the information. That doesn't necessarily mean the algorithms for searching will get you what's necessarily relevant.
Yeah. Okay.
But yeah, you can find it there.
Okay. Interesting. And now you touched on something a little before that pulled a bit of a trigger, because this is a conversation that comes up a lot in the community around intellectual property. And I never really considered, I suppose, things like patents and trademarks, or maybe trademarks, but definitely patents to be intellectual property. But I know we've had a number of members of our community that over the years have had issues with intellectual property going missing. And if I'm going to be honest with you, I actually was guilty of this myself in my last job through ignorance alone. Before I took an interest in business, I didn't really understand the whole issues around intellectual property or what any of that stuff sort of meant. And I know a lot of guys have, a lot of business information and databases and contacts and all this kind of stuff that they need to share with staff and team members and whoever, contractors, etc. And, from time to time, some of that stuff can fall in the wrong hands under different circumstances.
Sure.
So I'm curious, as a intellectual property lawyer, on a business scale, on a small business scale, if you will, what are some of the common instances that you would come into in regards to intellectual property, inverted commas, being compromised?
Sure. Well, I would say number one that for small businesses they don't worry enough about might be customer lists.
Yeah.
And now we're getting into what we would call a trade secret, and it's something that really a business doesn't actually sell as a product, but is there to make make the business go. Customer lists is the number one trade secret to me that a lot of businesses really ignore. I have seen employees that get fired that either, of course, have a customer list, or at least a partial customer list at home or on their phones, mainly because sometimes they wind up becoming friends with the customers. So sometimes that it's a little hard to draw that line. But customer list is number one. Number two, for what I see compromised, really does fall under copyright law most of the time. And that to me is some kind of marketing or design that winds up being copied. And sometimes it's really hard to stamp that out. But for a lot of companies, if they're making a product that falls under copyright law in the United States, you have to go get it registered, else there's nothing that you can do about this. And so what I would say is you really do want to make sure that if there is anything that falls under copyright law, you have it registered. This way you are able to either send the cease and desist letter or just file a lawsuit if possible. To me, those are the two big items that I think small businesses really don't take care of and wind up compromised the most.
I've got a client of mine here in Sydney Anthony, who rang me the other week. He's got a business. He's got a business that's been running for a number of years, and he wants to remove his name from the business and just to make it a little bit more scalable. So he did a bit of research, and he found there was a company that already had that trading name.
Okay.
So we basically had a bit of a conversation around, well, you know, what are some of the options there in regard to setting up a trading name? Because the funny thing is, he actually has secured the domain name, but he doesn't have the business trading name. Now, and I wasn't even sure at that point. I was like, oh, this is interesting. So you got the domain name, but he owns the business trading name. That must be something that comes up a lot, right?
It does. Although I think it's more of a concern in countries like Australia that might be Commonwealth countries that worry a little more about trading names than the US does. But,
oh, really?
Yeah. Like, for example, here in the United States, for example, Subway, the sandwich shop chain, their intellectual property, or their master franchisor company, was called Doctors Associates Inc. for many, many years.
Obviously.
Right, exactly. Exactly. I don't really know what they were going for. I don't know what that meant. These days, it's now called Subway LLP. So, hey, at least they've matched up the business name and the trade name. But the reason why I say what I say is because you can see it didn't really matter. Like what they traded in was Doctors Associates Inc., but the trademark was Subway, and all of their intellectual property was exactly what you'd expect from a franchisor, which is the trademarks in a food company, the recipes, the colors of the every location, the furniture of every location was the same or at least similar, and how you ordered the food and how you received it was the same, and therefore the menus were the same. So all of that is really what mattered more than what the corporate name was. So I here in the US, one of the when people ask me questions, the real issue is doesn't matter. And sometimes it really doesn't. Now, for a lot of smaller businesses, they want the trade name to matter. And so we want the corporate name and the trademark to match up. But I have plenty of clients where the trademarks don't have anything to do with the corporate name.
Well, what about this scenario then? Say he was a shonky businessman, and sorry, I should not speak Australian. Say he was a poor businessman, and he had the business trading name of this other fellow who's reputable, and he starts trading. He's got a website that's set up there. The website's terrible, and it doesn't really represent, and it definitely doesn't represent the caliber of the guy who doesn't actually own the domain name. But where does he stand legally, that guy who's got the registered business name, but someone else has got his domain name with a website on it that's not really ethical?
Well, this is going to be partially jurisdictionally based and partially not.
Okay.
And it really depends upon what you're looking to do as a business owner. From the domain name standpoint, the domain names are controlled by what we call the UDRP, the Universal Domain Name Resolution Policy. And it's run by the United Nations. We have arbitration for these particular disputes. The UDRP blatantly states that if you have registered the domain name in bad faith, which means that you registered it in order to, prevent somebody from using it.
Yeah.
Excuse me, that's going to be the issue.
Right.
Now, you have to look at the other side that's complaining as well. If that particular domain name is already, say, registered as a trademark in any jurisdiction, then we have to look at how strong that particular trademark is. It's not going to matter if it's just a corporate name. So in that particular instance, that's going to be a problem. In the United States, we do have something that we call cyber piracy for domain names that resemble trademarks. But again, the trademark's got to be registered. So you do face that particular bar.
Mm-hmm. I was listening to a podcast recently. I can't remember which podcast it was, but it might have been Tim Ferriss or something like that. But it was talking about they were talking to the guy who founded Dropbox. Mm-hmm. And they were saying when he basically got started, it was the Dropbox, and because somebody had Dropbox. And this guy, anyway, they wanted to buy it off him, and the guy said, "No, I'm using it." And they said, "Okay, whatever." So they just basically set up business. And as the business became more and more profitable, this guy saw it. And so what he started doing, well, he set up on that domain, he set up referral links to competitor websites. So anyone that was going to Dropbox.com was landing on that URL and then getting sent to competitors. Anyway, he said it was a bit of a.
I mean, that certainly does sound like a nightmare. And I actually did not know that story. But I mean, that's a classic case of activity that might not have been trademark infringement, but it certainly changed into trademark infringement because he was running a legitimate business. Therefore, his particular use of the trademark came before the Dropbox that we all know and love. So there's not particularly an issue until he goes and he changes his business model in order to trade off of the success of now the Dropbox that we all know and love.
Right.
And that's where he gets himself in trouble, is by trading off that success.
So let's just talk, I suppose, conscious of your time. I'd like to go through maybe some practical scenarios or examples of where this whole conversation might be relevant to the listeners out there. So let's say that I'm a builder and I typically build new homes. I'm guessing patent laws, I'm not going to need to register for too many patents unless I've created a product it's got to be something tangible, right? Well, it doesn't necessarily have to be tangible. As I said, in the United States, business methods are still receiving utility patents. So can you give me an example of a business method that's been patented?
Off the top of my head, a lot of the business methods that I can think of are very software related. So, so whether there is the infamous battle over Amazon's one-click patent, click once in order to buy something, as opposed to click once to do everything else on the internet. That tends to be what the business methods are. Now, in this particular instance, if a builder has found a new way to be efficient, that would certainly be something that might be worthy of a patent. If a builder has found a new mix of concrete for whatever particular reason, I mean, that certainly would be tangible, and that would certainly be something worthy of at least seeing if something is patentable. Those are the kinds of things when I've worked with my construction clients. You're right, it is in this particular industry something that is tangible. But yeah, usually it's some kind of modification, some kind of improvement to something that they've been working on for a long time, and all of a sudden it's like, well, hey, why don't I try this? And then when they try that, it turns into something better.
Interesting. And so, so the same builder, then he would obviously need to set about trademarking the name of his company and potentially his logos or anything from a brand perspective that might assimilate with the company.
Absolutely. And I certainly, of course, have seen, those builders that are just, little ragtag, bunch, and therefore it's probably not worth it from a business standpoint because they don't care about it. But I certainly have worked with construction companies and builders that span, 4 or 5 states here in the U.S. and even more, and therefore there's the trademark on the corporate name. They've got the logos plastered all over their cars, and so they wind up having a few different actual brands. Again, even though their consumers really aren't the end users.
So that's more to protect them though against competitors. Is that what you're saying?
Correct. So there's going to be there are a couple aspects of this. One is that they don't really want to be they don't want to be ripped off by competitors. So they don't want their competitors to be using their name, using their logos, which in any cutthroat business could happen without that particular recourse.
Right.
So they have that. But two, it's also a business asset because they're using it from that particular business standpoint. So it's used on all of their letterhead. It's used, obviously, as their domain name. It's used on their vehicles, whether those vehicles are, just the cars used for the business or whether we're actually talking about construction vehicles as well. Mm-hmm. So they put it on everything to make sure that it really is branded as much as possible.
Mm-hmm. And then what are they copywriting?
Well, I don't know that I see it too often in the construction industry. But what I would say is that in the United States, architectural plans do fall under copyright law.
Okay.
So, and I don't know if that's the case everywhere, but I would assume it is. And in that particular instance, what I would say is that make sure that the agreements, at the very least, are in place so that if something needs to be published, that the construction company isn't infringing the copyright of the architect, or of course, if the architect is in-house, which I've seen as well, obviously there's not going to be an issue there because it's an employer-employee relationship. But you certainly want to make sure that your agreements are drawn up correctly so that that's not an issue. If the architect is not around to control it, and maybe it's needed to be published either in some kind of government or municipality documents, or even if the construction company wants to kind of brag and show off some of the work that they've done, the building, would be protected by copyright because of architecture. So that can get a little weird and complex, but it doesn't really happen often. But
this is interesting because we have a lot of any of our clients, definitely, we encourage them to create project galleries for the jobs they've completed, and really make a conscious effort to showcase the work that they've completed. Now, could that potentially? So what we're saying is that potentially could be a copyright infringement, or maybe not.
Yeah, it's possible. Again, in the U.S., it's a little. I mean, it's probably the weakest copyright protection is the architecture copyright protection, and the reason for that is once a building is built, there isn't necessarily a copyright in the actual building, but on the same token, there are plenty of buildings that certainly are artistic and creative, and there are plenty of architects around there that would certainly not want to see their buildings not used improperly.
Right.
So that can be very gray.
And would you say, pretty much every website you go to has copyright 2019, all rights reserved written on the bottom of it. But I imagine that probably none of them have ever been registered or have a registered copyright, whatever you call it.
No, that's probably true. What the general risk, though, for a lot of small businesses is that their agreement with their website developer isn't done correctly, so that the business as the client of the website developer owns the copyright of the website, even if it's not registered. That's always something that I try to smooth out with my clients that are businesses. Like a lot of them really don't pay attention to who owns the copyright in the website.
And so with that in mind, what are some of the questions that they should be asking for these sort of things?
On the copyright side, if they're working with a website developer, just make sure that the agreement
clearly
allows
states theirs.
Yeah, exactly. States that the website's theirs. Again, on the trademark side, I would say you want to make sure that if you're speaking with counsel, if it really is a brand that is an asset of your company, you want to make sure you're speaking with counsel. You want to make sure you've done a trademark search, and just make sure that it's something that you can use, even if you never really plan on registering. But I would register because, hey, if a competitor does anything dirty out there and they try to use your name, that is another area in which you can hit them with. And then again, on the patent side, if you are creating something new as a part of your business, you really should be speaking to counsel to make sure that that invention is new and novel. And if it's something that's new and novel, then really that should be patented. And your path to monetization, maybe multiple income streams, is certainly opened up there.
Yeah, brilliant. Well, mate, I think we've pretty much covered everything. What are your thoughts?
I think we certainly have as well.
I'm definitely a lot wiser after this podcast. So thank you.
Oh, good. I was afraid sometimes with this particular topic.
No, I mean, look, it is a. If we're honest, it can be quite a confusing topic, and I think there's very few of us out there that really understand it. And I think what we've spoken about certainly helps get a bit more of an understanding. So thanks.
Hey, you are welcome, and I certainly hope that that was achieved out there.
Now, before we leave, you mentioned you got a podcast. What is it?
Sure. If you, I have the very colorful name of the Law and Business Podcast.
Wow.
Where, yeah, I know, right? I go figure. You can find it either on my law firm website at vernalaw.com. You can find it on iTunes. You can find it on the Google Play Store. If you can't find it under Law and Business, you can certainly find it under my name, Anthony Verna. And one thing I will certainly say is that I had a fun episode last year with an Australian barrister, and we talked about advertising law in Australia, because advertising law in Australia is, of course, based all around Paul Hogan. And
I don't doubt it.
So yeah, namespaces in Australia is actually a really, really new area of law. So we talk a lot about Paul Hogan.
Who, ironically, I think lives in New York now, doesn't he?
I believe you're correct on that.
There you go. Oh, that's great. And for any of the listeners out there, as Anthony mentioned, you can head across to Verna Law. That's VernaLaw.com. The Instagram handle is at Verna Law PC, and he's a Verna Law on Twitter. I think I pretty much got everything. You're going to leave some resources behind, but it's some checklists as well within the resource section of the SiteShed website. So thank you, Anthony. Guys, you can head across there and you can download those. And if you need any questions specifically relating to anything intellectual law, reach out to Anthony and get him to answer those for you. Anthony, I dare say we're probably going to have some questions come through from people that might hear this and might need some justification on a few things. So I may need to call on you again. I hope you're willing.
Absolutely, not a problem.
Not going to charge me every 15 minutes, are you?
No. Although I'm glad that you, for whatever reason, read my mind, because I bill in 15-minute increments. I have plenty of colleagues. I have plenty of colleagues who bill in 6-minute increments, because that's 1/10 of an hour. And I'm like, I don't know about you. I hate living my life in 6-minute increments, and it's totally unnatural. And
the whole 15-minute incremental charging thing, I think, is of something that's very foreign to pretty much anyone that isn't a lawyer. So.
Oh, I agree with you on that as well, which is why, for the most part, I try to make sure that if somebody gives me a project, I say, all right, it's going to take 5 hours. It's going to take 3 hours. It's going to take 20 hours, whatever it is. So that this way I say, look, that's what it's going to take. So that this way I don't have to do stuff like that. I mean, there are times when it's impossible to do anything other than that. But for the most part, we really try to avoid it, because I don't like living my life like that. And I'm sure that my clients don't like being billed like that either.
No, they definitely don't. So that's great. All right. Well, guys, if you have any questions, you'll see this come across social media or in the newsletter, or if you're listening to this and you want any clarification or anything, by all means, just leave some comments there and we'll get those answered for you. Otherwise, Anthony, that is a wrap.
Thank you, Matt, for having me.
Thank you for listening to another episode of Toolbox Talks. If you're liking what you hear, then you can head across to the siteshed.com, where you can join our community by signing up to our Toolbox Talks. You'll get sent a weekly notification, which is basically a highlight of everything that we've spoken about during that week, along with any other industry news that may be relevant or specific to the trades. If you're enjoying the show, you can head across to iTunes, Stitcher, or SoundCloud, where you can leave us a review. That would be fantastic, and all the reviews get read out in the show. Likewise, if you have any friends or colleagues that you think would benefit from the show and the episodes that we create, then please go ahead and share it with them.